What you know, Alibis, welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Sunday, July 13th, kicking off a full week of episodes. Gonna play catch up on the cases that took a back seat while I was out in Phoenix twice for Lori Daybell's trial and life in general. We're gonna go through Donna Adelson's hearing that took place this past Friday on July 11th, where they discussed several issues. So let's jump in. This is the defense motion to extend previously ordered deadlines for witnesses, exhibits, and pretrial motions in completing discovery. The judge asked the defense if they've discussed with Donna about the raw data they're seeking, specifically for Charlie Adelson and Donna, the emails which has the potential for reopening the door of the conflict. Just a reminder, Donna's trial was halted after Charlie did not waive conflict with Dan Rashbaum, who was his attorney at trial and originally was representing Donna, which resulted in Donna finding an entirely new defense team and again delaying that trial. The defense says they have not discussed that with Donna because they do not think it would. It's in the same category as the raw, unredacted, unfiltered emails from Donna's own account that the judge authorized the defense to obtain in April. Her attorney says in that motion to compel, they asked for the raw, unredacted downloads for the emails and were repeatedly told that they had been provided to the defense. They retained an independent forensic data expert and provided the expert with the materials that was provided to them. Then the defense was informed by the expert that those were not the raw forensic extractions, and it was requested the defense obtain those raw forensic extractions of the emails. The defense says he copied and pasted the expert's explanation in the motion to compel. And it's been a month since that request was made, and he believes they are entitled to that. The intent is to verify the Celebrite reports the state has prepared, and their expert needs that raw data to do that. Now, just a reminder, Celebrite is used to extract raw data off of cell phones, devices. We hear about that a lot in our cases that we cover. Prosecutor Kappelman has no objection, but does ask that any reports that are generated by the defense expert as a result of the data being re-celebrated to be provided to her in a timely manner, because based on the version and type of the program to verify the defense's report to the state's report, there could be differences involved, and she does not want to be surprised by that at trial. Judge Everett granted that motion, but says if any of the communications include Charlie and Donna's former attorney, Dan Rashbaum, or information that was provided by Charlie previously, they will have to revisit the issue. The defense says Sergeant Corbett from the Tallahassee Police will testify as their phone expert, and their defense expert has been communicating with Sergeant Corbett. So once the order is signed, Sergeant Corbett will upload the data to a portal so that the defense expert can then download it. The second motion was to extend deadlines for the defense. The court has extended the April and May deadlines, and Judge Everett asked what's preventing these motions from being filed. The defense says they were only able to depose Jason Newland, who is the chief investigator for the state's attorney office, and Sergeant Corbett last Wednesday, and they plan to depose Special Agent Patrick Sanford Tuesday before they file these motions, and these depositions are necessary before they can file. The judge points out there's other depositions scheduled for this coming week, and the defense says yes, on Monday, Tuesday, and Thursday. Judge Everett says the reason they have deadlines, whether it be discovery or any deadline cutoff, is to be able to proceed orderly to trial. And the defense proposed dates for filing were within 4 weeks of when the state fulfilled their obligations. The defense said they filed those on June 27th, and that deadline was 2 weeks ago. Their intent isn't to delay the start of the trial, but the proposed date of when they would file is very fluid right now. The judge asked the defense if there's anything they can do to convince him that it'll be filed by a certain date, and what they're asking to do with filing these motions after they think the state has complied. The defense says it's a moving target because they haven't received all the discovery from the state. During a deposition the day before this hearing, they learned the state's expert had conducted call frequency analysis between Donna and Charlie for a longer period of time that had been previously disclosed, and their expert is going to send the defense a report if he's completed it, and also send PDFs of the actual call frequency analysis that's contained in the state's demonstrative aid. He's saying this because it's difficult for the defense to file any appropriate motions or provide appropriate responses to demonstratives or exhibits when they still haven't received everything from the state. The judge wanted to know how many motions are we talking about at this point, and the defense says potentially 3. Judge Everett asked, as to these 3 motions, would any of them affect the trial start date of August 19th? And the defense said no. Prosecutor Kappelman has no objection, but says that they be afforded the same grace. There's 1 or 2 things they intend to do that could go past the deadline, and all indications are that both sides are working diligently to get this done. She gets the fluid aspect the defense mentioned because there are a couple of orders that are fluid that she's wrangling with, and she's trying to minimize it, but things do come up past the deadline, and these emails have contributed to that. Judge Everett asked Prosecutor Kappelman what she thinks will come up on the state's behalf. The prosecutor says other than the emails, there is a defense witness listed that they've discussed trying to get a deposition from, and she wants to get that done before the deadline. That's a handwriting expert, and the state doesn't have the name of the expert witness or that witness's report. That's something that's pending and would be in direct violation of the judge's order. She also wasn't aware of the issue the defense brought up regarding Sergeant Corbett having done a report, but he does do work to generate the slides that were prepared and discovered by the discovery deadline. And Prosecutor Kappelman says, when asked about how did you come to these conclusions, the expert is going to say, I looked at the data. Well, they want to see the data, and we don't object to that, but I think it's the same thing as a discovery violation. The judge says the final pretrial hearing is August 8th, and all motions need to be filed by July 31st so they can proceed to an orderly trial on all merits. Anything not filed by that date from the state or the defense are subject to be deemed as waived. He said if you need to seek leave to amend as to the specific motions filed on this date, you may do so. He says, again, this is not an arbitrary date to throw something out. To have an orderly trial, both parties need to see what you intend to raise as pretrial legal issues that the court needs to rule upon. There will be no trial by surprise for either side, and he asks if he's making himself clear. The judge moves on. He asked if the defense has renewed their motion in limine concerning the Latin Kings. The defense says yes. The judge asked if the state has filed any motions in limine by the previous deadline, and Prosecutor Kappelman said they renewed the motions, but there's nothing new. The judge says any previous ordered copies of all these motions, when they're filed, will need to be served upon the court, and to please do so if they haven't already. So what's the deal with the Latin Kings reference? One motion filed by the defense asked the judge to reconsider a previous ruling which prohibited mentioning Rivera's affiliation with the Latin Kings gang. The defense argued this information is relevant not as to character against Rivera, but to illustrate Donna's state of mind regarding her perceived opinion about the dangerousness of the individual who committed Dan's murder. The prosecution said they had no new response to that request. So again, the deadlines. The judge wants all pretrial motions to be filed by July 21st, and then a final motions hearing on August 8th before trial start date. Now, on the next episode, we'll go over the witness list and also motions and decisions by the judge that I've missed due to me being in Phoenix back to back twice for Lori Daybell's trial, as well as some family issues like Grammy getting sick, where I took a week off just to take care of her. So we're playing catch up, but we are going to be ready for this trial. And I will be live streaming every day, so come watch with the Alibis. I am planning to drive down to Tallahassee for a few days to sit in at trial, so I'll be bringing you some stuff with boots on the ground down there in Florida. That's it for this episode. Just wanted to recap that hearing, and we will have new episodes out all week long. Until then, I hope you guys have a great rest of your Sunday, and we will see you soon.